It's sometimes impossible for co-ops and condos that want to build or improve their property to do the work without accessing the building next door. And sometimes your neighbors are not so neighborly and won't grant you that access. But there is a remedy, and Heather Stiell is here to tell us about it. Hi, Heather.
Hi, good morning, Paula.
Good morning. I understand you represented a building that wanted to add an extension and ran into an interesting problem. Can you tell us what happened?
Yes, absolutely. Our client was a condo that wanted to build in the rear of its property. That required the condo doing some foundation work and having access to the lot line. And so they would have had to remove a fence. And the neighboring property, the owner got into a dispute with our building as to where the property line was. They had actually built up to our building's fence and were encroaching on our building's property. And so instead of negotiating sort of reasonable terms of access, they were demanding a payment in order to allow our client to have their land back, to use their land. So it was in effect sort of a backdoor adverse possession sort of argument.
That seems pretty unreasonable. What happened next? Did you petition the court?
Yes, we actually did petition the court for access. And the court essentially found that because there was no adverse possession litigation before the court, that the terms of access that we were requesting and had proposed to the court were reasonable. And so, in lieu of allowing the neighboring property to extract this exorbitant payment from the client, the court actually granted the terms of our access agreement and granted to the neighboring property a license fee, which is usually what would be granted in an access case of this sort.
Is this typical that a court, how does a court typically intervene? Do they help the parties negotiate an agreement?
No, the court usually only gets involved if and when the parties can't reach an agreement on their own. Then the party that's seeking access can petition the court under the Real Property and Proceedings Law. And the statute, which is RPAPL 881, basically provides that the court will provide access on such terms as justice requires. So it's still in the discretion of the court whether to approve the terms of an access agreement, but essentially the statute builds in a presumption that if the access is necessary to accomplish whatever construction or whatever project is needed to be done, then the court will essentially allow it, but just seek to make sure that the terms are fair and reasonable.
And in this case, or in general, what things should boards be careful to include in an access agreement with the neighbor, particularly one who's being a little bit bulky?
So generally, the more sort of reasonable an agreement is, and the more that one can demonstrate that it's necessary, the more likely a court is to approve the terms. The court can also impose some of its own terms. But at the outset, the application to the court needs to be supported by facts that demonstrate the extent of the work that that is proposed to be done, the duration of the access that's proposed, the necessity of it. So an affidavit from an architect or an engineer explaining why the access is necessary, demonstrating that the work can't be done in a less intrusive way, that sort of thing.
So I would imagine in this case, the fact that you got the license agreement meant they sort of ceded the issue of where the boundary, where the lot line was. Is that right?
Well, in this case, the court essentially informed the neighbor that their demand was unreasonable and wasn't going to be granted. So the choice was to either agree to reasonable terms of access and thus be awarded a reasonable fee, or to just lose and have all of our terms granted.
Now, of course, you always want to sort of bake in provisions, right, to make sure that your license agreement covers you and protects you. Are there certain provisions that boards should make sure they include in these agreements?
Sure. So, from the perspective of the neighbor that is being intruded on, let's say, they want to make sure that there is insurance in place so that any damages that are incurred as a result of the access can be covered. The license fee generally covers just their inconvenience for the neighbor accessing their property. But certainly, if there are, specific property protections that need to be in place, and these things can be like, temporary scaffolding, things to support excavation work, and those are generally things that, the court would look for to be sort of reasonably included in an agreement. From the perspective of a client like ours, or one that's seeking access to a neighboring property, one would want things like specifically defining the access period, making sure that there are terms in the agreement that are clear about when it begins, such as after inspections are done, after permits are granted, and also making sure that there are damages or remedies clauses in case any sort of disputes arise after the agreement is entered into, that if either of the parties breaches the agreement, or if access is refused, or something is not complied with, that there are remedies that the party seeking access can look to.
Now, for the board, could one of those provisions be if the neighboring building doesn't meet the terms of the agreement, what can you do? Can you withhold payments? Is that a good tactic?
That can be written into an agreement. In fact, the license fee, the terms of a license fee, are usually monthly. The court will impose it almost like a sort of use and occupancy fee. And so what that means is one would want to specify in the agreement that those payments are tied to specific points in the access period. They're almost akin to the progress payments that one would put on a construction contract.
Mhm.
So, on a certain date, if the access isn't being provided, that particular payment would be withheld.
Now, where do things stand with the building now? I would imagine that negotiating an agreement, isn't the end of the story, that problems can still come up. Has that happened here?
Problems can still come up. We've hit a few hitches. We've had some back and forth negotiations with opposing counsel. But as for now, things are going smoothly. Usually the court will put in a provision that if there is any difficulty with access or compliance with the agreement, that the parties can come back before the court. So that would be the ordinary remedy that most parties would seek.
Okay. Now, just to sum up, Heather, what's the takeaway here? What do boards need to know?
You want to engage, I think, competent counsel, someone who is experienced in helping to negotiate these agreements, to make sure that they're reasonable at the outset. And if the need for a petition arises, to make sure that you have all the pieces in place to demonstrate to the court both the reasonableness of the terms and also just the necessity of the access that you're seeking.
And do disagreements sometimes go to litigation? So is that something also you should be prepared for?
They often do. I'd say probably 7 or 8 out of 10 of these types of disputes do end up in some type of litigation because, properties are close, land is finite, and it's almost a foregone conclusion that when a building wants to make some sort of change or improvement or alteration, that there will be issues that involve neighboring properties.
So sort of boards should be forewarned that problems are likely to come up. Heather, thank you so much for joining us today.
Thank you, Paula.
Bye-bye.